Hi, my name is Nurhaz Rosna and I would like to explain about the Article 5 protects the right to life and liberty. So Article 5 ensures a number of basic fundamental human rights. Article 5 subsection 1, no person may be deprived of life or personal liberty except in accordance with law. So the example of cases is Hong Neo Equipment Sdn Bhd and Liu Fok Chuan and Arnold. Life also comprises the right to live livelihood. However, this right is not an absolute right because it may be taken away by the operation of law. For example, if a person is convicted of murder, he will be sentenced to death. It's not considered a deprivation of his right to life as. Next, right to liberty, Article 5, subsection 2, where the complaint is made to High Court or any judge thereof that the person is being unlawfully detained, the court shall inquire into the complaint and unless satisfied that the detention is lawful, shall order him to be produced before the court and release him. Habeas corpus, Article 5, subsection 2, it is used to bring a detainee before the court to determine if the person's imprisonment or detention is lawful. Next, right to be informed of the ground of arrest, Article 5, subsection 3, where a person is arrested, he shall be informed as soon as may be of the grounds of his arrest and shall be allowed to consult and be defended by a legal practitioner of his choice. So the example of case is Abdurrahman and Tan Joko. A person arrested on suspicion of committing an offence is entitled to immediately know the reason of his arrest. If the reason was withheld, the arrest and detention would amount to false. Finally, right to be brought before a magistrate within 24 hours. Article 5, subsection 4. This right will ensure the detainee has not been subject to cruelty. However, only applicable to citizens, while for non-citizens, the period is extended to 14 days. If a person is arrested, the police must, within 24 hours, produce the arrestee before magistrate to get a remand order. Based on all the examples, I can conclude that despite they are rights, however, they are not absolute. That's all from me.
Next is Article 10, which states that every citizen has the right to freedom of speech and expressions, to assemble peacefully and without arms, and to form associations. Citizens have freedom of speech, assembly, and association, but these freedoms may be restricted by Parliament for reasons permitted by the Constitution. The courts have said Parliament may only impose restrictions where they are reasonably necessary. Raja Petra Kamarudin is the best example to show the limits of freedom of speech in Malaysia. Raja Petra Kamarudin is a controversial blogger that started Malaysia Today. He has been caught twice under ISA, which the first time was accused of plotting the violent overthrow of the government of Tun Dr. Mahathir Mohamad, and the second time was accused of insulting the Islam religion. It all started with a blog entry on the website Malaysia Today, which was deemed to contain writing that incite the Yang di-Pertuan Agong, degrade Islam, and incite hatred and violence between local ethnic groups. Even though in the federal constitution, Malaysian citizen has the right to have freedom of speech and expression, assemble peacefully, and form association, however, in Malaysia it is not absolute.
Today I'm going to explain about, is it true that fundamental liberties that are provided under federal constitution are absolute? My opinion or my answer towards that question is fundamental liberties that are provided under federal constitution are not absolute. Based on the fundamental liberties, on Article 11 states that every person have a right to profess and practice their religion and subject to clause 4 to propagate it. So here I'm going to explain, is it true that Malaysian fundamental liberties show that every person have a right to profess and practice their religion? The case that I have researched is about apostasy case that involving Ina Joy and it impact Malaysian law and society. Why does it impact Malaysian law and society? After 1988, the judiciary was made subversion to Parliament and has no jurisdiction in respect of millimeter within the purview of Sharia courts. And analysis on the details pertaining to the continuing dilemma over whether the civil or the Sharia laws, the correct avenue to decide apostasy case will be specifically highlighted. People wanting to renounce Islam argue that they should not be subject to Sharia courts and the only recognized Muslim, given that they no longer profess with the state-led Islamization under the Mahathir administration previously on 1981 to 2003, state Islamic law were being promulgated and streamlined among the 13 states in Malaysia to include specific state law criminalizing apostasy and several others. Apostates were required under several state Islamic law to go through a period of rehabilitation, hence a constitution of jurisdiction began under Article 12118 in 1988 of the Malaysian Federal Constitution. Because of that, a curious decision had arisen at this time where freedom of religion may be denied on such step as a constitutionally protected freedom. Once a case is perceived to have come under the purview of the Sharia courts, the civil court, which is High Court and Federal Court, had upheld the principle that in a case of conversion of Islam, the jurisdiction belongs to the state Sharia courts. Only the state Sharia court is empowered to deliberate and declare on apostasy. Connectively, this paper aims to scrutinize and understand the selected apostasy case involving Ina Joy, which will enable us to use this case point as an important term of reference in highlighting the issue on the freedom of religion as guaranteed under Article 11 and the cognizance of it. Article 12118 in this said case of Ina Joy, the court ruled that the freedom of religion Article 11.1 over Muslim does not give the plaintiff the freedom of choice to practice the religion for the choice. Conclusively, this paper affirms that the fact the so-called right is subject to Article 11.4 and Article 11.5, as the issue of a personal religion is directly connected to the rights and obligation of that person as determined under state Islamic law. That's all my explanation for the Article 11 cases, which is the freedom to profess and practice our religion, to show that the fundamental liberties that are provided under Federal Constitution are not absolute. Thank you.